You should keep such folders in next time you post, you can keep folders
उसी में है वो सिराजी को
Am I audible? Can you all hear me? Good morning, everyone. I, Animesh Srivastava, along with my co-host Vineet Mishra, both students at National Law University, Delhi, welcome you all to this event that boasts of the presence of so many esteemed personalities. Welcome to the National Seminar on the concept contractualization in employment, law and policy, challenges and solutions, being organized by the Center for Transparency and Accountability in Governance, National Law University, Delhi, in collaboration with the Frederick Abel Stiftung and National Labour Law Association. We're extremely grateful to all our guests for the presence here today. We have with us Dr. Praveen Sinha, President, National Labour Law Association, Mr. Anup Srivastava, Program Advisor, Labour and Industry Relations, FES India. Our guests of honors, Mr. Ulrich Stork, Country Director, FES India, and Professor Suresh Srivastava, Secretary General, National Labour Law Association. Our chief guest, Mr. Colin Gonzalez, Senior Advocate, Supreme Court of India, and founder of Human Rights Law Network. Professor Dr. Harpreet Kaur, Registrar and Professor, National Law University, Delhi. I once again thank all our esteemed guests and would now request Professor Ajit Singh Man, Director, Center for Transparency and Accountability in Governance, for the felicitation of our esteemed guests.
Thank you so much.
Yeah.
Now, to cut off the metaphorical ribbon, I would like to request Honorable Registrar Ma'am to inaugurate the session. Ma'am, please.
From here only, just the welcome address.
Yes.
Good morning, everyone. Dr. Praveen Sinha, President, National Labour Law Association and Professor of Practice, Emeritus Professor of Practice at CLS TES. Mr. Ulrich Stork, Country Director, Frederick Ebert, Stiftung, India. Professor Suresh C. Srivastava, former Professor of Law, Labour Law, KU and Secretary General, National Labour Law Association. Advocate Colin Gonsalves, Senior Advocate, Supreme Court of India, Founder HRLN, New Delhi. Mr. Anup Srivastava, Project Advisor, Labour and IR, FES India. Professor B.T. Kaul, my colleague Dr. Ajit Singh Man, other dignitaries present here, the participants, ladies and gentlemen. It is my privilege to offer a welcome to all of you here for this event on the National Seminar on Contractualization in Employment Law and Policy, Challenges and Solutions, which are co-hosted by CTAG, the Center for Transparency and Accountability in Governance, Frederick Ebert Stiftung, and also National Labor Law Association in collaboration with National Law University, Delhi. The contractual employment has always been important. I have been teaching labor laws quite a lot in the business law when I was a part of a business school. Last 11 years, I have not taught, but I have been working on my book on labor law. So I know that contract employment, especially contract labor, has always been an area of concern, especially after the COVID and its impact and the consequences on the migrant workers and the contract employment. This area has again taken a kind of vigor where everyone needs to research upon that what should be the situation for dealing with such uncertainties and why there has been a reason that we have not been able to deal with the contract employment situation here in India especially. There are certain reasons which are provided that why do we have contract labor. I'm not going into the provisions of the labor laws, which I think also apply to contractual employment in general also, that there is rigidity of law, the salaries are comparatively low, although there is a question whether it is truly in sense of the contract employment. Less employee benefits are required to be given. If you have more contractual employees, the bargaining power will be less. In case of labor laws, there will be no direct relationship of principal employer and the labor. Again, the reason is that there is a quick completion of work, that the work is very easily done through the contractual employees. And also the contractual employees, they get a sort of flexibility in their hands that whenever they want to move, they can move around. So these are some of the areas which I think we have to also see that whether they are applicable in all scenarios which are related to contractual employment. Being here in the university, we also have contractual employees and we know the difference between the two. And we try to balance it out that the contract employees, they should not feel that they have been disadvantaged in any way when it comes to the regular employees. But then the regularization of the contract employees is a major concern for us also. If I look into some labor law statistics, and I could not find actually 2021 statistics, but as per one of the report, in 2014, 2015, we found that in 10 sectors, we had more contractual labor in comparison to the regular labor, especially in the area of manufacturing sector. And also I got some statistics from 2015, 2016 to 2018, 19 in government PSUs. And we found that there was increase by 86% when it comes to contractual workers, right? So they have used the term workers. So we have to see that what type of workers they are referring here. So being at the National Law University, Delhi, obviously labor matters are important to us and it's important area. But as a university, when we look at the mandate which is given to us by the UGC and also the national education policy that we have to go into interdisciplinary areas, there are certain questions which come to our mind. Is one of the sessions has already included the impact of liberalization, privatization, globalization. One of the sessions is there, but especially in context of this century, this decade, because the COVID has, changed a lot, and from globalization to we have been for last 6-7 years or more than that have been talking about deglobalization also. So whether it's actually globalization or deglobalization, we need to really have a word on it. There is an impact of technology and also artificial intelligence when it comes to any sort of employment. So what is going to be the interface between technology and contract employment? Whether there will be changing relations between the employees and employers here. There are requirements of specialized skills So whether we are able to get those specialized skills in the regular employment, or whether we have to go for, contract employment. If we are talking about contract employment, we cannot ignore the business altogether. So the impact of contract employment after COVID on the supply chain management, that's important area, I think, that we have to keep into mind. And being a business law professor, I think that has been my area of interest also. So probably some research can also be done in this area. Adherence to contractual terms. That's a very important point when it comes to contract. So what we are writing in the contract and how long we are reviewing those contracts and then renewing those contracts, right? So renewal of the contracts on the same terms and conditions also creates a sort of expectation, right? And I don't say that they can be legitimate expectations, but the expectations in the mind of employees that they will someday be regularized also. So whether it's a legitimate expectation or not, I think you are the best judge to, research upon it. So these are some of my thoughts which I noted down today in the morning while reaching to the office, that may be of some interest to the panels here. It's my pleasure to welcome you all, and I'm sure that these 2 days will be really good, having a lot of discussion and coming up with some publication. Mansur, are you proposing some publication? Okay, so we look forward to the presentations and maybe some publications, even if not in the form of full papers, maybe some of the thoughts that generate during these panel discussions. I welcome you all and thankful to all the guests, everyone here. Thank you. Thank you so much.
Thank you, respected Professor Ma'am, for the inaugural speech. As we all are aware of that the topic for this seminar is contractualization in employment, law and policy, challenges and solutions. I would now request Dr. Praveen Sinha to enlighten us about the concept and evolution of contractualization in employment. Sir has been president of National Labour Law Association for more than 14 years now. He is also serving as the Secretary of Indian Industrial Relations Association and Secretary General of the Social Security Association of India. Moreover, he has also worked as the senior advisor at the Indian office of Frederick Ebert Stiftung for more than 24 years. Over to you, sir.
Thank you so much. Thank you, Professor Kaur, for your inaugural statement. And also, I'm so glad to see my colleagues here. Colin we have been working together since 1994, when we first brought out cases on Indian labor laws with focus on contract labor. And I see now that circle coming back together here, and to see how we look at the contractualization in employment. At the National Labour Law Association, this subject has been of immense importance to the association and also to our members, majority of whom are trade unionists and also the lawyers. And we have been looking at the law, not only the contract law, but labor law per se, in the context of constitution. Because we perceive in NLA law to be an instrument that provides steps towards meeting the constitutional goal. And as such, there has been many occasions, especially in the last few years, where we find in our discourses that there has been serious contradictions between the constitutional promises and the governance to some extent. And there we consider law to be a major instrument to provide a channel towards a meeting point of the 2 or 3 interests, or 3 interests plus the society, the environmentalists and other things. But before I share with you the overall concept and basis for organizing this workshop, may I formally welcome by joining Professor Kaur. Welcome, Colin. senior advocate at the Supreme Court, and a dear co-fighter on the issue of human rights, on the issue of labor rights. And as I said before, that the human resource law network that he heads or that he founded, and which has over 200 advocates as member, right, has extensive spread over throughout the country, and that has been an instrument source of learning in legal matters. Let me also invite dear colleague Mr. Ulrich, the new director, to this course, and we are so glad to see him here because he has been, or his institution has been, a source of link in enabling us fight the challenges that the world of work faces, especially since 1991, when we had continuous focus on the issue of labor, on the issue of organizing the workers vis-a-vis the focus of the sustainability business and also the constitutional promises. Let me also formally welcome my colleague Srivastava ji. I call him Guru in the law because I remember in my student days, the two books I really referred, one by Dr. Srivastava and one was by on economics. He was also a colleague, but unfortunately he passed away. I'm glad to see Comrade Amarjit Kaur here, and we will wait for her input when we formally start. Professor Paul, Professor Dhar, Yajuri Didi, and all of you, colleagues, because this discourse is primarily focused on you, so far we are concerned. And why it is focused on you is that the program is being organized in the context of prevailing socio-political condition. And there we find that, of course, we have law since 1947, and we do have amendments incorporated here and there. But when we look at the law, making of the law, we find that there are factors, interest parties influencing whether it's employer, whether it's a government, whether it's a workman or the community at large. Every person has interest. And when the law comes, it is supposed to be the result of collective discourse and collective mindset of the all interest group, and in keeping in view the constitutional right that provides to us. Also kept in view are the international commitment India makes world over, whether it's at the ILO or we look at the United Nations, which as early as in 1948 gave us Universal Declaration of Human Rights, which clearly is part of in the fundamental rights that are given in the Constitution, specifically stated there. Coming to the issue of contractualization, it's not a new in India, not in India's whole of South Asia, and not a new world over. That contractualization is a part and parcel of running a business. But we need to understand what does it mean, because as a lawyer, as a person who is involved in the legal matter, we look at the law as instruments for securing rights that are provided in the Constitution. And whether the instruments that are being introduced, is it inconsistent with the law, or does it lead to securing rights that are already guaranteed in the Constitution? And there we find certain challenges. Of course, business is important. I think no interest group, whether it's a lawyer, whether it's a trade union, whether it's environmentalist, no one says that my right should be there to help with the business. Business has to survive because that's where the meeting point is. If the business is there, you have trade union, you have employment, you have trade union, your business is there, the businessman is there, also there. So in that context, there is no dispute with regard to looking at the viability of the business from whether we look from the trade union point of view or whether we look at the business point of view. It will be overstating that the trade union is not concerned with the viability of the business. The contract, I look as in India, if we take only example of India, we have short-term contract, we have long-term contract, we have verbal contract, and we have no contract, and we have written contract. The difference in all these is that whether it leads to identification of the person as a rightful person to be given the rights that are guaranteed in the Constitution or in the laws that is previously. And when we talk about 80–90% of the workforce involved in verbal contract, no contract, which directly relates to the violation of the human right and labor right of that person. No business can survive for long if a majority, one section of the contributor is left unprotected and uncared for. There's always power game in the world of work. That's why we call it collective bargaining and collective begging. That's the two language normally comes. When you have a power equilibrium, and there's a power gap between employer and employee, we call it, trade union call it collective begging. The bargaining is there when you have equal partner. And it is the responsibility of the lawyer and the government to see that the weaker is protected to the extent that it is able to at least reach an equitable power level so that there is a bargain within the overall scope of the survival of the business and also the promises that are there in the Constitution. We will see today and tomorrow. We will hear those who are active in the field. We will hear from our chief speaker, keynote speakers, Srivastavaji and Advocate Colin, to give us food for thought, which will be debated upon in the technical sessions that we have. We will also have the papers presenters, and we will be interested in listening to their input and their thinking insofar the contractualization is concerned. But the NLLA, as I said before, that irrespective of whether it's a workman or an employer, what we are looking at is the link between right and the law. Whether the law, whether the contract that is entered into, whether it's a casual or short-term contract or a long-term contract. First of all, there is a contract or not. When we say 80 or 90% are undocumented worker or informal worker. And it's not only in the private sector, even in the public sector. Government is the major employer of contract labor. And government is the body that gives us the law and also provides instrument to ensure that the law that is given is also respected. So in that context, we will be looking at that how far the existing instruments takes us to a situation where rights are better protected. We will also interested in listening on the four labor codes that is under debate for the last over 4 years, and more specifically after September 2020, when it was hurriedly passed. There has been concern. We organized a number of discourses on the subject of labor code, and there was no specific event where their concerns were not expressed with regard to the code that has, whether it has taken us forward or it has taken us back. Any developing society, whether it's we're talking about global south or global north, law has to be such that it keeps in view the current scenario, and also it leads us to a level which is more progressive, more green economy. What Professor Mann has given us, he made this hall green, and in ILO we talk about green economy also, and whether it has led to the overall satisfaction of all the groups, whether employer, government, or the trade union. With these words, I once again welcome all the dignitaries. I welcome all of you. Specifically, my focus is the students also. You need to intensively hear the invited guests we have, because all of them have come with extensive experience, and we have borrowed their valuable time so that they can share their knowledge and views to you. And we have Ulrich also comes from Germany, and Germany is one economy where the governance is a social economy where you have a kind of trade union as a major partner. They say co-determination law. I think I'll allow him to speak all the things that will come. But I'm glad to see all of you. And I join Professor Kaur in welcoming you for this workshop, and urge upon all of you, specifically students, to nichoro, jitne bhi resource person, nichoro, so that maximum input from them for your knowledge. Thank you very much.
Thank you, sir, for enlightening us about the seminar and sharing your insights. I'm now privileged to invite our guest of honor, Mr. Ulrich Stroh, to share a few words with us. Sir is the director of the Frederick Ebert Stiftung office in Delhi. He has previously worked for the FES in the United Kingdom, Greece, Guinea, Central America, and Morocco. FES is a German NGO which has been committed to the ideals of social democracy. FES was established in 1925 in the memory of the first democratically elected president of Germany. To this day, FES has the mission to promote freedom, solidarity, and social justice through political process in Germany and abroad. FES has a network of more than 100 offices across the globe. So,
Good morning and warm greetings from Friedrich Ebert Stiftung. I'm very happy to be here, and I'm very honored to be one of your guests of honor this morning. I would particularly like to acknowledge the presence, and please forgive me my bad pronunciation of the names. Professor Harpreet Kaur from the National Law University here in Delhi, Dr. Pravin Sinha, the president of the National Labor Law Association, Professor Suresh Chandra Srivastava, Secretary General of the National Labor Law Association, Colin Gonsalves, the Senior Supreme Court Advocate, all the faculty members of the National Law University, distinguished speakers and participants, and dear students. At the outset, I must say that I'm pleased to be attending this inaugural session of the National Seminar on Contractualization in Employment, Law and Policy Challenges and Hopefully Solutions, being organized as a 2 days event on the 17th and 18th, and to have the opportunity to meeting you all. We at the FAS for the past several years have been collaborating with the National Law University and its Center for Transparency and Accountability in Governance and the National Labor Law Association on issues concerning the world of work, and more so from the law and policy framework perspective. The FES, as it was already said, is the oldest German foundation, established in 1925, what means we are soon 100 years old. And we are next year celebrating 40 years of presence here in India. FES is committed to the advancement of both social, political, and economic development in the spirit of social democracy through civic education, research, and international cooperation. We are committed to conduct projects which are embedded in promoting a just and fairer society governed by the principles of social justice. The past 2 years have been extremely difficult, and what started off as a health pandemic in no time turned into a worldwide economic crisis. World over countries are reeling under economic impact and rising inflation. Millions of jobs have been lost, and particularly the women's participation in the labor force was going down. From the people's perspective, continuity in employment, both for those already in employment and for those looking for employment, has been a major challenge. We all know employment forms have been evolving in the past many years. Gone are the days when a person has been employed in a particular company and retired at the same company. Contractual forms of employment has become the contemporary feature of labor markets around the world. Their overall importance have increased over the past few decades in both industrialized and developing countries, as they have become more widespread across economic sectors and occupations. New terminologies have evolved and are being used to define this changing nature of employment, like fixed-term contracts, part-time employment, on-call work, 0 hours contract, subcontract labor, temporary agent work, just to name a few, or agency work. For some people, working in contractual form of employment is by choice. Those who want to enjoy more flexibility in their employment. However, for most workers, contractual employment is associated with insecurity. When contract employment is not voluntarily, it increases workers' insecurities. The basic issue remains the lack of employment security, lower wage payment when compared to work performed by regular workers, no guaranteed working hours, the lack of social security coverage, less opportunities for job-related trainings, and in terms of workers' representation and exercising the fundamental rights at work. The growth of contractual employment is the outcome of multiple forces. It reflects changes in the world of work brought about globalization and social change, such as, for example, the increase of the role of women in the world's labor force, who sometimes cannot commit to regular employment, but still want to augment their family income, who see contractual work arrangements as an option. Also, at times, laws have encouraged the use of contractual employment, as there are gaps or gray areas in the law that provide fertile ground for the development of non-standard work arrangements. Some of these gaps have resulted from the decline of collective bargaining in countries. We have to change and adapt all the time. A few years ago, work from home seemed to be an alien concept, but is practiced widely today, not just in information technology sectors, but across industries. Similarly, the rise of on-demand platform work has been significant and is witnessing high growth rates. In India, the Apex government think tank, Niti Aayog, has predicted a phenomenal rise of workforce seeking employment in the gig and platform economy from the current 7.7 million to about 23.5 million by 29 and 30. The challenge remaining is how do we ensure that these new emerging forms of employment remain as close as possible to being decent jobs. This is a concern for economies around the world. Allow me to share with you 2 responses from Europe, from the larger European Union and from Germany, which somewhat aim to ensure that decent working conditions prevail for this segment of workforce. The first is that some years back in 2019, the EU directive on transparent and predictable work conditions was introduced. And last month, in August this year, it was its deadline for all EU members to transfer it into national laws and make it enforceable. This directive took into account the fast changing reality of the labor markets and to ensure that people have the right to more complete information about the conditions of their employment and more predictability on their day-to-day lives. Anyone who is a worker will have the right to receive a statement of their terms and conditions within a week of starting the work. Where the work patterns is entirely and mostly unpredictable, the workers must state the number of guaranteed paid hours and the pay for work performed in addition to those guaranteed hours. A ban on probatory periods exceeding 6 months, unless on an exceptional basis what is justifying that. And it will become unlawful to prohibit workers from taking up employment with other employers outside the working hours, unless this can be justified by objective grounds. Workers with at least 6 months service will have the right to request a new form of employment with more predictable and secure working conditions and to receive a recent written reply within a month. Where mandatory training is prescribed by law, prescripted by law, the employer must pay for it. It must count as working time and, if possible, it must take place during working hours. So this was this European Act. And second is a new law in Germany, the German Supply Chain Act, which shall come into force from January 23 next year. This is widely seen as a response for Germany-based MNCs to comply with human rights and environmental standards along their supply chains, especially in countries where national regulations are not enforced properly. A lot of the workforce along the supply chains in the developing countries work as contract workers. This act is an attempt to ensure due diligence and compliance on working conditions for such workers, including aspects as living wage, better occupational health and safety, and ensure no forms of slavery, child labor, or forced labor exists. These are new achievements and still need to be implemented, but probably steps into the right direction. Having shared these examples from Europe, I'm sure with such diverse participation from the academia, the policymakers, industry, workers association, and the students studying law here, this seminar, through its sessions and paper presentations, would be able to deliberate and come up with concrete sets of recommendations. It is obviously work in progress, and we need to continue this dialogue and come up with effective laws and policies in the pursuit of realizing decent work for all. And personally, I already want to present my apologize for not being able to participate in all the discussions of this 2 days seminar. I have another activity of our foundation and I have to catch a flight this afternoon, so I need to leave a bit early, but I wish you fruitful and inspiring exchanges. Thank you very much.
Thank you, sir, for sharing such a deep insight into the topic and flagging some of the most pressing issues. I would now like to request our guest of honor and keynote speaker, Dr. Suresh Srivastava, to share his thoughts about this seminar. Dr. Suresh Srivastava was consultant of ILO on a project on worst form of child labor and resource person in a training program organized by ILO and National Judicial Academy. Sir was a member of the Sectoral Innovation Council appointed by the Prime Minister of India to review labor laws. Sir is presently Secretary General, National Labour Law Association and Honorary Professor of Maharashtra National Law University. The National Labour Law Association has organized more than 300 seminars workshop, and discussions on a variety of subjects, such as the industrial relations law, contract labor, public sector enterprises, and among others, adjudication. In 1989, the association undertook a major research project called Simplification, Rationalization, and Consolidation of Labor Laws. The code has been extensively quoted by the Second National Commission on Labor. Without further ado, I would like to request Sir to share a few words.
Mr. Harpreet Kaur, Dr. Praveen Sinha, Mr. Orlik, Mr. Colin Gonsalves, Dr. Anup Srivastava, Professor B.T. Kaul, Dr. Mann, distinguished guests and participants, ladies and gentlemen. I deem it a privilege and honor to have been asked to address and to deliver the keynote address. Friends, as you're aware that the contract labor is the most exploited section of human labor who has been denied wages equal to their counterpart. They've been denied privileges like gratuity, even bonus and other benefits. And quite apart from this, they have been subjected to a lot of inconvenience. And it is said that the contract labor starts with a minimum wage and he retires with a minimum wage. And this was the contention which is generally leveled by the trade unions. Well, I think with this introduction, I come directly to the contract labor regulation because that is the law, the specific law which regulates the contract labor. Well, if you look to this, it is in operation for the last more than 5 decades. But what you see is that even though the word is contract labor regulation and abolition, the word abolition doesn't occur at all in the text itself. And therefore, unlike the Bonded Labor System Abolition Act, there is absolutely no reference. And if you look to Section 10 of the Contract Labor Regulation Act, you'll find there is a lot of complications and a lot of problems which arises it. And one of the, therefore, I have to come to Section 10, which talks of the, doesn't talk of this, what you call, what would happen to the workers if the notification is issued. In other words, there is no mention of the status of the contract labor after the notification is issued. And therefore, in this regard, I would like to mention that the Supreme Court had an occasion, in the absence of any provision for the abolition of the contract labor system, the Supreme Court, in a majority judgment in the Air India Statutory Corporation versus United Labour Union, observed that though there is no express provision in the Contract Labor Regulation and Abolition Act for absorption of the contract labor, when the engagement of the contract labor is stood prohibited on publication of the notification under Section 10, from that moment, the principal employer cannot continue contract labor and the direct relationship is established. But this ruling could not survive even for 5 years. And what we see is that we have seen the Constitution Bench decision of Steel Authority of India, where the same issue is said, and what was said in this case is they have reversed the judgment of the Air India with prospective effect, not with the retrospective effect. And here it was said that neither Section 10 of the Contract Labor Regulation Abolition Act, nor any other provisions of the Act, whether expressly or by necessary implication, provides for automatic termination of service. And therefore, if you look at the consequences which arise out of the Steel Authority of India, you'll find the Supreme Court said that contract labor working in the concerned establishment at the time of issue of notification will cease to function. And then it was said that the contract of principal employer with the contractor in regard to the contract labor comes to an end. And the employer cannot employ the persons. Now, there are three issues which I have an occasion to write in the Journal of the Indian Law Institute. And the first is about the criterion for determining the appropriate government. Now, the Supreme Court said that that in each case, whether the central government would be the appropriate government, and so you will have to find out in each case. And what I said is that if by the holding that where the authority to carry on the industry for on behalf of the central government is created by statute, it would be said to be run under the authority of the government. According to me, it has rendered 316 words out of 404 words out of the useless appendage. Indeed, the court misread the intention of the legislature in enacting Section 2A. We believe that if the Air India and Steel Authority of India, for different reasons, fail to appreciate the significance and implications of specific inclusion of 25 establishment. Quite apart from this, there is an issue which has been raised in the Steel Authority of India is about the giving preference in employment. Now, Supreme Court said that in this case, preference should be given to the contract labor. Now, the difficulty is Section 25H says that preference will be given to retrenched worker, and therefore it has brought a conflict between the statutory provision and the judicial decision. And how we're going to resolve this issue, that's a very wide issue which need to be looked into. Well, quite apart from this, the Supreme Court pointed out in this case that see what would happen, particularly when the worker, when the contract labor or the contractor doesn't have the job to employ some, because he doesn't have any other establishment where he can place the contract labor. What would happen to him if he retrenches the worker and if he refuses to pay the retrenchment compensation? Who will pay the retrenchment compensation? Whether the principal employer will pay the retrenchment compensation? These are the issues which I have addressed in as early as 2001 when the Supreme Court decision came. Then in 2019, we have seen quite area which I think we cannot support by any reason whatsoever. Now, we have seen in 2019 a Supreme Court decision of Director Steel Authority of India versus Ispat Khandan Janata Mazdoor Union. Now, in this case, what happened? That the notification was issued by the appropriate government prohibiting the employment of contract labor. But what happened? The establishment continued to employ the persons, their contract labor, and with the same contract of service, even for the abolition, when the prohibition order was issued, the notification was issued, and therefore, see, just bypassing what has notification has been issued, they have continued to employ the persons with the same terms of employment. Now, is it an abolition? Or is it a prohibition? Or what is this? This is an area which needs to be addressed. And if you look to this, I had an occasion, here, in this case, the tribunal said this is sham contract. I think I rightly said that it is sham contract. The High Court said it is a sham contract. But when we reached Supreme Court, they read it in a quite a different manner, which I think that it is rather astonishing if you look to the reasons which have been given to this. Now, what the Supreme Court said, I quote, in our considered view, the tribunal under its award dated 16th of September 2009 has rightly arrived at the conclusion that contract was not sham and bogus, and there shall be no automatic absorption of the contract labor on issuance of the prohibition on notification under the Act. Now, and then they also said that the High Court decision was therefore wrong. But what the Supreme Court, what their tribunal said was entirely different. What the tribunal said, the tribunal held that employment of contract labor through contract was not sham and bogus before notification on 17, but after publication of the said notification, by operation of law, the contract through contractors could be considered to be but it becomes void and sham. In other words, the Supreme Court misread what was said by it's read and say what the observation which was made before the notification. And this is how the Supreme Court is trying, say, with due regard to the Supreme Court, I think there is a misreading of the provision. Likewise, if you look to the decision, there's a complete contradiction between the paras 21 and 49 of judgment. I'm not quoting because of the time constraint. Then the Supreme Court ignored the Constitution bench. It brushed aside the Constitution, even though they referred that they are following the Constitution bench. They have brushed aside the same, and the court, what I said here in one of my articles, which have been published elsewhere, that court conveniently ignored the ruling of the Constitution bench of the Supreme Court in Steel Authority of India, on issuance of notification, the prohibition prohibiting the contract labor system. No contract labor can be employed by the principal employer in any process or operation. But here, unlike this, they allowed to continue this. And this is what, again, what I said is that even the application of beneficial legislation principle also has not been followed. Here, I just like to mention what Lord Denning said, and I quote, "When a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set the work on the constructive task of finding the intention of the parliament, and then he must supplement the written words so as to give force to the life and intention of the legislation. A judge should ask himself a question: how if the makers of the act had themselves come across this in the texture of it, and they have to straighten out, he must then do as they would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the crease." Unquote. I think with this observation, I come directly to the another Supreme Court judgment of which you are aware, a Constitution bench of Supreme Court in Secretary of State of Karnataka versus Umadev. And here the Supreme Court held that absorption, regularization, and permanent continuance of temporary, contractual, casual, or daily wage of ad hoc employees towards the rules of the constitutional scheme of public employment cannot be granted by the court. But unfortunately, some of the judges, two judge bench, have tried to overlook this one. They have said that they just mentioned the case, and they have, in the process of distinguishing, they have in fact overruled the Constitution bench. This is a very unfortunate situation which is happening. Quite apart from this, let me come to the code. And I know out of the 4 codes, the only code which refers to the contract labor is the Occupational Safety, Health and Working Conditions Code. Now, if you look to this OS code, I'm referring here as OS code. If you look to this, it has enlarged the coverage of the contract labor. Now, under this, contract labor includes even what you call as the interstate migrant workers. But here, the problem is that for the contract labor, for the application of the contract labor, instead of 20, it has now been raised to 50. And for the for the interstate migrant labor, which forms part of the contract labor, for them it is only 10. So it is very difficult to reconcile how we see the contract labor interstate migrant workers who forms part of the contract labor we can be distinguished in that regard. Likewise, I find that it is difficult to support the two diametrically opposite line of approach in the OSH code in regard to the application of the contract labor. Likewise, the OSH code seems to have adopted a line of approach followed by the Supreme Court in Dinanath case. And the Supreme Court said that consequences of engaging contract labor through unlicensed contractor would be the principal employer would be liable for the prosecution. Now the question is, what the Supreme Court is telling here, it is following what was said in regard to registration of the contract labor. Now, in that regard, my difficulty is that if you look from that angle, it is given license to the principal employee, pay 1,000 rupees fine, and you don't have to go for registration. You can even violate the provisions of Section 10. I'm not favoring the trade unions or the employer. I'm just telling you the legal position in that regard. And I think this is the most unfortunate situation which we are facing. Another practice which is prevalent in several establishments is to invite new tenders and on the expiry of the previous tender. And this process, contractors are changing, but the contract labor remains the same. I think it is a case of sham contract, but unfortunately, in none of the Supreme Court decisions, they have tried to bring it within the purview of what you call as a sham contract. Well, there are many issues, unlike the Contract Labor Regulation Act, there are several issues, but I personally feel that I'm not going to the details because the time, looking to the time, but whatever may be the positive aspect of the OSH code, the code has not on the whole succeeded in providing much needed relief to the contract labor. This is all the more so because Supreme Court, there's a tendency on the part of the employer to avoid the liability under various labor legislation by resorting to subterfuge, by trying to show that their employers are in fact the employees of the contractor. I think I have painted with a broad brush the picture about the judicial role of judiciary as also of the legislation. I think with these words, I thank you all for listening.
So I would like to apologize that I have to leave. There is another program which is beginning at 11:30. So please excuse me. Advocate Karan, I apologize sincerely. I will not be here. Thank you so much. Thank you.
Thank you so much, sir, for giving your insights on the topic. Moving ahead, it gives me immense pleasure to call upon our chief guest for the event, Dr. Colin Gonsalves, to share a few words. Sir is known as amongst the best human rights lawyers in India. He is a senior advocate at the Supreme Court of India and the founder of the Human Rights Law Network, an Indian national network of public interest lawyers. Sir and Human Rights Law Network expanded their work to represent unorganized workers, slum dwellers, amongst others. Throughout its history, Human Rights Law Network has focused on using the legal system to achieve practical results for the poor and marginalized sections of the society, winning over 1,000 cases. So its work has focused on securing rights for India's most vulnerable people, such as bonded laborers, ethnic and religious minorities. Remarkably enough, Sir litigated his first case while still in law school on behalf of 5,000 workers locked out of their jobs. So without taking much of your time, I would request Dr. Gonsalves to address this.
Thank you, Professor Mann, for inviting me today. And thank you for that little potted plant, which I'll take home. My wife will be very pleased with that.
And thank you, Praveen, for being here today. It's wonderful seeing you after quite some time. We have a relationship that goes back many years with the FES. I used to say 5 years ago that there are dark clouds approaching us. But today we are in the middle of a storm. There's thunder and lightning all about us. And I don't exaggerate when I say that the working class is going to be slaughtered in the next 3 or 4 years. It's a very short-term period where this government, perhaps together with assistance from the judiciary, will completely decimate the working class, the trade unions, and working class standards of living. I somehow feel that some of these seminars and workshops, and I've been responsible for that, over the years, we use the language of the past. We use the language that we used 10 years ago, 5 years ago, but now even the language of 3 years ago has become obsolete and archaic. And we are unable, the trade unions are unable, we lawyers are unable, the academics are unable to see the world in India in its reality. The labor codes are going to decimate labor. When I say that, there'll be many who will protest and say, no, there's this line in this labor code. There's this rise in workers from 20 to 50. There's this definition of contract labor, this labor, that labor, we are going to benefit. And I've attended meetings where there are clashes between the organized worker unions and the unorganized workers who say, for years, you have dominated the scene and you've taken all the benefits. And look at us, we are the same. So at least we're getting the labor code. So we'll go ahead. It's a dream. It's a dream of organized labor. It's a dream of unorganized labor. Everyone is going to suffer. And one of the reasons why I came for this conference is to make an appeal to anyone who's here, someone who's here, who's capable of taking forward the agenda. Since I'm a lawyer, I speak from the point of view of the courts. Take forward the agenda of us coming together in a convention, not to do gupshup and chat about the code and this judgment of the court and sale judgment and error. Not for that, but to work out a plan of action for the leading labor lawyers and the leading trade union activists active in the legal field, 100, 150 of us to get together, to work out a plan to draft the petition, to challenge the labor codes. So that the moment the labor code is notified, and as you know, when the labor code is notified, all existing statutory benefits will come to an end in that second. So the labor codes and the labor unions and the labor lawyers have to be ready to be in the Supreme Court on that day, mention to the Supreme Court and get a stay on the labor codes. That is the short-term but most important agenda for labor that we must do. Are we ready? We are not. Are the organized unions ready? No, they are not, surprisingly. They're deeply divided and confused and ambivalent. And they are the best. They have the best people in them. But they are confused. Are the unorganized unions ready for the combat against the labor codes? They are not. So like sheep to the slaughter, we will go quietly into the regime of the labor code. It will be notified. The moment you go to court, you'll be told that all these acts have been repealed. Sorry, your cases are not sustainable anymore. And that will be the end of labor resistance. I came here to suggest a plan of action, and I hope somebody present here today will help us take it forward. We have a network of lawyers in the country. We have prepared a draft, but that's not good enough to go solo. We must go with the academics. We must go with the unions. And we must go with the labor activists who practice in courts on a day-to-day basis, who know the situation intimately. a little bit about the background and why I say the judiciary, although we go to the judiciary, has become a thoroughly unreliable institution for us. Thoroughly unreliable. And it is the judiciary in the sale judgment. And you must understand this as students of law, teachers of law. Too much of teaching is based on this paragraph, that paragraph, this judgment, constitution bench, overruling 3-judge bench. Too little is understood of the politics of law, the heart of law. Students must learn the heart of the judgment, not the verbiage and the camouflage and the paragraphs and the quotations and so on. Air India said a very simple thing. The Contract Labour Act says if you are perennial work, it must be prohibited. Air India said a very simple thing, that the moment a notification comes abolishing the contract labor system, the workers will be permanent. Makes sense, isn't it? Perennial work means they're working for 10 years, 15 years, 20 years. Notification comes, abolish. Make them all permanent. So simple. Heart of the judgment. And then, of course, came judges who were globalized, who couldn't bear this idea of workers becoming permanent, who already then, and I'm talking of the year 2001, were dreaming of a country with contractual workers, an army of slaves. 2001, and all it takes is one judge to say, this is bad, we must change the system, this is not good for India, we must change. Some other countries have a contractual system, we must bring contractualization in India. And then you have a 5-judge bench constituted. Now, what does SAIL say? Forget the paragraph, forget the language. What does SAIL say? Abolishment of contract labor system abolishes contract labor. Like Garibi Hatao of Indira Gandhi, Garibi Hatao. It's not the system of poverty must go, lekin Garib ko hatao. It's like interpreting it like that. So the contract labor system abolished meant abolish contract labor, and the core of the judgment in SAIL, the moment the abolition notification comes, which means that the central government agrees that the work is perennial, essential, the workers must go. Can you imagine a judgment of a 5-judge bench? Can you imagine? Every law student must understand the core of the judgment, the politics of the judgment, the venom in the judgment, the anti-labor venom in the judgment. But what are you saying, sir? You are 5 judges, constitution bench. You are saying that when the notification comes for abolition, the workers are abolished, they lose their jobs, they'll be thrown out. How can it be? So that was SAIL. And let me tell you, the consequences are enormous. You never realize the world outside, even law professors sometimes. Law students, of course, live in a world of their own. And now with the education system, I'm sorry to say, you all will even more live in a world of your own and fantasy. So when you go out into the world, on commercial law, you'll be top. On many things, you'll be top. But when it comes to human rights and so on, you live in a world of your own. Totally a world of your own. Because you have to learn to understand law as combat. It's a combat between the rich and the poor. It's a combat between the have and the have-nots. And it's a combat in which you, as a young lawyer going out into a very troubled India, young lawyers in their 20s, 30s, you will be the new leadership of India. And you'll be called upon to reconstruct this nation, which has broken down, totally broken down. And so you'll be called upon to take sides. You'll be called upon to have strong views against powerful people. Maybe you'll fight against your parents, you'll fight against your professors, you'll fight against a politician. That is the situation in which you find yourself. What happened after sale? India became a country of slavery. I've heard it said India became a country of contractual workmen, this, that. Forget all that. Once you're contractual, you can't form a union. Your contractor will terminate you, and through another contractor, you'll can't form a union, unionization stops. If you're getting less than the minimum wage, can you say to your contractor, sir, I want minimum wage, please? If you don't get gratuity, pension, provident fund, can you say, I want pension, provident fund, sir? Make no mistake. There's nothing to do. Contractual is just a polite term. And I know in Europe, they use the word contractual and so on, but we don't use that word here anymore. Yes, you have turned the country into a country of slaves. I practiced in Bombay as a labor lawyer for 20 years with Datta Samant. Datta Samant taught me one thing which I've always preserved. He was my first guru in life, perhaps my only guru. He told the workers, disregard the courts, don't go there. For adjudication on wages, it will take you 10 years. Sorry for saying this, but he used to say me, so I'll be truthful. Pick up a hockey stick and come with me to the factory gate. And he would do that. You pick up a hockey stick and everybody pick up hockey stick, go to the gates. And I don't say violence is a good thing, but violence has its place in society when it's used by the poor against the rich. And wage increases of 50 rupees, 75 rupees, 100 rupees after 7 years of litigation, believe me, it will be 1,000 rupee wage increase for the workers. These workers come to see me today after so many years. I've been in Delhi now 20 years in the Supreme Court, and I talk to them from the multinational corporations. Can you imagine the big corporations of Germany, France, the UK? They come here and I ask them, how much wages do you get? And it's the minimum wage. Can you imagine skilled workers in skilled jobs getting the minimum wage? 30,000 rupees, 35,000 rupees, which in Bombay then they got 60, 70,000 rupees. And today the wage for them should be upwards of 1 lakh rupees per month. That's gone. The unions have gone. Now I want to say a few words about the labor codes. It's an evil instrument. You must understand government, law, formulation of bills, making of laws. Please don't be misguided by camouflage. The words, the paragraphs, the headings, the cliches. Don't be misled. It's an evil instrument. What will you see at the end of the day? I know there's code 1, there's code 2, there's code 3, there's code 4. At the end of the day, what does government want? One, it wants the labor courts to close down. There's a mood in society, to get out of adjudication by courts and to go into mediation, conciliation, arbitration. It's very strong in the labor field. They want the labor courts, the industrial courts, the system of adjudication to be abolished. No more judges. Instead, what will you get? A mediator, a conciliator, an arbitrator, a facilitator, and an arbitrator. What does it mean that when you get sacked, you can't run to the labor court and get a stay? Which is what you want. That's the main thing, that when I'm sacked, I go and get a no more. And who will these conciliators, mediators, and so on be? Hold your breath. The very same persons from the Labor Commissioner's office. Forgive me, some of them are very good, but they are cesspools of corruption. The Labor Commissioner system in this country, to get a reference to the court, which should take 15 days, will take 6 months, 8 months. Why? Because it's a cesspool of corruption. And from that cesspool, they will pick up people who they will make your mediators, conciliators, and so on. That's the end of adjudication. That's the end of courts. Now you have a new threat. Insolvency has come up. The main litigation going on today is insolvency litigation, section 53 of the code. Get a sense of the smell around us, rotten smell around. Get a sense of what is happening. Insolvency says that when your company goes to insolvency, you may have worked for 20 years. You may have provident fund, gratuity, this amount, that amount. Under the old insolvency laws in the company code, you would get your dues, pretty good dues, in priority to the banks. Today, you'll get 2 years of wages. After 25, dedicating your life, 25 years of service, 53 of the insolvency code will give you 2 years wages. And if you see what's happening in the insolvency courts, it's a massacre of workers. You worked all your life, you're due to get so much, and you go to the court and the what do they call it, the RP, what's the phrase? The resolution professional will tell you, sorry, stay out. You have no locus to come here, and proceedings are going on merrily with the unions and the workers be kept aside. And the workers lose in every deal. And this is again a cesspool of corruption, this whole system of NCLAT and CLT. Cesspool of, will go on and on and on and on. You'll give the money to the banks, you'll give the money to the person who's buying the factory, you'll give the money to A, B, C, D, E, and you won't give the money to the workers. And that's what's happening. You've seen the data on suicides of workers, right? It's come out recently. A huge increase in the suicides of workers. We may think that some of the judgments we got for interstate workers and for migrant workers during COVID period were great. It was great because we look at the newspapers and say it is great. We were part of that litigation and we got an order here, we got an order here, we got an order there, we got an order there. For 5 cases or 10 cases that we filed, 6 cases were dismissed. You please go to the government. I come to the court because the government is not listening to us about the condition of workers. Don't believe the papers and say that, oh, wow, what wonderful job was done. During COVID, people were thoroughly massacred. And the orders that came from the courts were never implemented or hardly ever implemented. So the interstate migrant worker situation remains the same. The casual worker, the ad hoc workers. Let me tell you about construction workers. And Mr. Dar is here, so he knows the situation intimately. Some 70,000 crores of rupees are lying in the construction workers' account. We go to the Supreme Court gave a wishy-washy judgment saying that you must use this money for workers. Everyone is putting their hands into this 60,000, 70,000 crores. Everyone is getting the benefit except the construction workers. And again, I tell you, it's the labor commissioners and the groups that operate the official system that have subverted this system. Governments are taking money. Some governments are taking a loan from this money. But 70,000 crores, you can give lakhs to each of the construction workers and change their lives and make it better. So at the almost, I would say, at the fag end of my career, and I'll stop. At the fag end of my career, I will say, I don't have any hope, really, in what is portrayed to the public. It's lies and lies and lies and lies, exaggerations, embellishments, falsehood. You struggle for labor, you teach labor, you fight for labor, you must fight without compromise. And if you have your only tongue as your weapon, you must use your tongue and your brain to speak the truth as it is. don't get into the cliches of the past because the past has receded. The presence is upon us. And we have, despite my, despair, let's say, we can change things. And I think if we stand up to these labor courts and go to court, on the day the codes are notified, that, sir, this code, look at this section, it abolishes, it repeals every single labor protection given to workers since independence. The judge on that score alone will be shocked to see the labor code. You do labor codes, but the laws must coexist side by side. The judge would be shocked and grant stay. And so, even though the dark clouds are upon us, it's quite possible that individuals within the system can stand up to the tyranny of this government, the absolute tyranny of this government, fight back, and perhaps even win. Thank you very much.
Thank you, sir. It's always a pleasure to hear you. The way you explain things, it acquires special places in our mind. With that, sir, I would now request Mr. Anup Srivastav for vote of thanks. Sir joined as Program Advisor, Labour and Industrial Relations in FES before having over 20 years of experience working with the labour movement in South Asia. He worked as the Education Officer for the Building and Woodworkers International in the South Asia Projects Office and looked after the trade union development projects in the sub-region. He has been involved on sub-regional program on child labour and improving health and safety at work. So,
good morning, respected Colin Gonzalez ji, Senior Advocate, Supreme Court of India, Dr. Suresh Chandra Srivastav ji, Secretary General of the National Labour Law Association, Dr. Praveen Sinha ji, President of National Labour Law Association, Mr. Ulrich Stock, the Country Director of FES India Office, Dr. Harpreet Kaur in absentia, the Registrar and Professor, National Law University, distinguished guests, speakers, participants, and dear students. It gives me immense pleasure in delivering the vote of thanks on behalf of the FES, the National Labour Law Association, and the Center for Transparency and Accountability in Governance, housed here in the National Law University. I think employment in the post-COVID world has become a very pertinent topic globally, and its changing forms have become quite contentious and are impacting individuals, families, and society at the large. We have had a very thought-provoking and stimulating inaugural session, which has, of course, brought in diverse views and has certainly helped in setting a broad framework for our discussions for this two-day seminar. We would like to deeply extend our sincere gratitude to Shri Colin Gonzalez ji, who was the chief guest for today's inaugural session. And thank you so much for that inspiring speech. Dr. Srivastav ji, who is a well-known figure in the legal fraternity, thank you so much for your insightful key address. Dr. Praveen Sinha ji, thank you for taking us through the seminar theme and setting the agenda for the 2 days. Again, Professor Harpreet Kaur in absentia for her warm welcome and her inaugural address. I think our word of gratitude also goes to Professor Sri Krishna Deva Rao, who is the Vice Chancellor of National Law University, who although could not be with us today, but has provided close guidance for the conduct of this today's event. All the session chairs, speakers, I see a lot of familiar faces. Amarjeet ji is here, Professor Kaul is there, Rajendra Dhar ji is there, Sanjay Upadhyay ji is there, a lot of familiar faces, and all the paper presenters and participants deserve our deep sense of appreciation. I think, in today's busy world, it is not easy to organize and bring together, such a wide range of people, especially on a weekend. I think a word of thanks goes to the constant effort of Professor J.S. Mann, along with his colleagues and the support staff at the National Law University in making all the necessary arrangements for the smooth conduct of this today's seminar. Thank you once again, one and all. Thank you so much.
Thank you, sir, for your kind words. Now, I'm honored to request Professor B.T. Kaul, practicing advocate, Supreme Court of India, and former chairperson, Delhi Judicial Academy, to present mementos to our esteemed guests.
Lest we forget it. This is the preamble to the Indian Constitution. Oh, what's the
With this, we mark an end to the inaugural session. And once again, thank you all for joining. We'll be beginning with the technical session as well as a paper presentation after a short break. We request you all to kindly join us for high tea, placed outside this room. Thank you.
Yes, sir.